And without that, you're kind of stuck. People can't get to your money and take care of your bills, not even a spouse. People make assumptions that just because you're married, you have access to everything. And a good example of that would be retirement accounts. Those are owned by an individual, and just because you have a spouse doesn't mean they can call and make a withdrawal or do a transaction on the account. Or real estate. If you own it jointly, you can only transact business as to your interest, but not the spouse's. So that's, it's not like a joint bank account. That's different. Either one can go in and deal with the bank account, but those other types of assets, the spouse cannot. And then the afterlife estate planning, which I've touched on, and the central documents might include and would include a last will and testament. So if that is your primary document, then that's going to not only address who would be guardian, but also what happens with your estate when you're gone. Who's going to be, we call it personal representative, other states call it executor, and always name a backup. And then that's the person who kind of comes in, collects everything, deals with final expenses, and then transfers assets to your intended beneficiaries as named in the document. And I'm sorry I've got duplication here, but the other type of document that might be central is a revocable living trust. And there are all kinds of trusts out there, but this is really the most common type if you're doing traditional estate planning. And that's not in lieu of a last will and testament, but it will actually address more of what your intentions are regarding transfer of assets on death. Even with a revocable living trust, you'd still want or need a last will and testament, because that's where you address guardianship, but also just in case there are assets that aren't in your trust, you have to deal with them outside of it, and I'll talk a little more about that. So a last will and testament, and I'm sorry, that second bullet doesn't belong there regarding revocable living trust right under it, but these three sub-bullets go with the last will and testament. Under Arizona law, it can be holographic. That means in your own handwriting, without any witnesses or a notary, as long as you address all material provisions. We probably would advise against that in most instances, especially if you have a child with special needs or special abilities, because the planning is much more complicated than maybe you could capture yourself. We would recommend it be self-proving. That just means that you've executed it in the presence of two independent witnesses and a notary who all avow that you are over 18 and capable and did it of your own free will. And with that, then you don't have to prove up a will in court later when you're gone. So it saves your family the trouble of having to do that. If you rely primarily on a last will and testament, you may, or your family may be having to do a process called a probate when you pass away. And everybody's like, oh no, not a probate. Let's avoid it at all costs. Well, we're here to tell you it's not that onerous. It's not that costly. And in Arizona, we have an informal process that's pretty seamless. But that is the process that does allow your personal representative to get appointed, have authority to deal with your affairs, and transfer assets to your intended beneficiaries. And it's a function of really how much equity you have in a house and how much other in personal property you have. And those thresholds are pretty low. It's $100,000 equity in a house and $75,000 in other personal property that trigger the need for a probate. But again, it's not as bad as you might think. But if you do want to avoid a probate, then the revocable living trust may be the better option for you, among other reasons. And that does provide for continuity throughout the lifetime in terms of if the trustor, you would be the trustor establishing the trust, becomes incapacitated or at time of death, because that's a separate legal being or entity that exists and doesn't die when you die or become incapacitated when you become incapacitated. It survives that. And for that reason, there isn't the need to have a probate to transfer assets. But crucial to a trust is putting your assets in it. So a lot of people neglect that, and it's not enough to have your trust and think everything's in it. You actually have to transfer title to your trust. So that's crucial. Otherwise, you'll still have a probate to put it in your trust.
Does that include, like the house 401k, can that be placed into the trust also?
Yes, so the trust can hold any number of assets. One distinction, though, with retirement accounts is only the individual can own a retirement account. A trust cannot, but we would address the beneficiary designation and what that designation should be when you're gone, whether if you're married, is it going to be the spouse or is it going to be the trust? And then Karen had a comment? Or?
No, that was your 5 minutes.
That's my 5-minute warning. Okay. She knows a lot about retirement accounts. Okay, so, and then I know what's, of most interest probably to many of you is the special needs trust. And what we would stress is it's a special needs trust, not your child, him or herself, that should be the beneficiary of your estate plan. That trust can be built into a will, so it's testamentary. It doesn't exist until you pass away. It's in the body of that document. It could be a sub-trust of your revocable living trust. So you have this global trust for yourselves while you're living, and it says when you pass away, that provision for your child is continuing to be held in a special needs trust for their benefit, or it can be its own trust over here that exists, while you're living, and you or any other number of people can fund it during lifetime. More often than not, a special needs trust is not necessary until after the death of the parents. And at that time, it will be funded with the assets from their estate. There's some unique circumstances where we might suggest create it during lifetime and start funding it now. But parents often feel compelled to start setting aside money for their child in a formal manner. And we actually discourage that because it has other implications in terms of your duties and responsibilities, reporting it to governmental agencies and such. So there's nothing you can't do out of your own pocket like you always have that you can't continue to do in that manner. So we discourage oftentimes formalizing that until death. And then I did mention, though, for tax planning purposes, some people may create a separate trust and start funding it during lifetime, but that's becoming less and less of an issue as the exemption amount goes up. Don't confuse your special needs trust. In the context of an estate plan such as what we're discussing, the special needs trust will be what we call a non-grantor or third-party trust, which means someone other than the beneficiary, your child with special needs, is establishing the trust and funding it with their assets. People often confuse that with the special needs trust that somebody with a disability funds with their own assets. So if you have an inheritance because of a failure to plan that is distributed outright to your child, that's their money now. Too late to put it in a special needs trust that you or someone else might have created. They have to do a different type of trust, and that's called self-settled or first party, meaning the beneficiary is creating it and funding it with his or her own money. So you don't need to worry about that for the most part. So there's a lot of confusion about that because the self-settled or first party trust has very specific requirements under the law. One of them is to reimburse Medicaid. So you don't want to unnecessarily provide for reimbursement to Medicaid. That's not a requirement of the type of trust you would be putting in place for your loved one. And then many of you probably already have familiarity with ABLE, the Achieving a Better Life Experience account. It's very nice to have that option now for our special needs individuals. And in the context of planning, what I would say is it is a nice complement to a special needs trust, but it doesn't replace it. There are limitations on funding it. That account does require paying back Medicaid. So in your estate plan, you probably don't want to do that again unnecessarily, and you probably want to provide for who would be the beneficiary after your special needs child is gone. And you can do that in a special needs trust that you create, but the ABLE account will have to be first reimbursed to Medicaid. So Arizona has legislation in place. We've got a task force working on implementing or getting the account up and running. It's not quite up and running yet. I've been told it should be by mid this year, right in time for First Place's opening. And but in the meantime, you can open an account up in other jurisdictions or states that accept out-of-state beneficiaries, and most of them do. So I've given you this website that is really current in terms of what states have an account up and running and who will accept out-of-state beneficiaries. You just can't walk into a bank and open this account. It's just like a 529 college savings account. So there's a designated institution or custodian of these accounts in each state. And that's the only way in which you can have an account. So I think I saved the best for last. Communicating your intentions is key. It's not enough to put something on a piece of paper, whether it's a will or a trust, and sock it away in your drawer, and then when you're gone, somebody finding it and trying to figure things out, because there's a lot that will not be in that document, and it doesn't have to be. So you really should start those discussions now with your family or the people you intend or would like to participate in your child's future when you're not able to. You want to make sure they're up for the job, and they want to do it, that they understand what that would involve, that they know what your intentions are, because your child, adult child, may not be able to communicate that, him or herself. You're the one who knows this best. And so that brings us to also the letter of intent, which we've got here in hard copy form, but I think it's also available online. And that's a great document to really help you know what information is important. You just take it for granted that you know everything about your child. Well, that next person doesn't. And so this is a place you can capture that, not just their doctors and medications and such, but who are their friends? Do they like soda? What are their triggers? I mean, really breaking it down. And that's not a static document either. So you can update that as you need to. What is important to understand, it's not a legal document. This is not a legal document, but it is a great complement to the other documents that you have, and it will really help the fiduciary, the trustee, the guardian who succeeds you to do their job the way you intend and would like them to. And I think my 5 minutes is up. Yes, Mary? Did you have something, Larry?
Yeah, just a question. What's your thought on co-guardianship?
Good question. Certainly now, if you're married, that makes a lot of sense for, the parents to serve as co-guardians. It is interesting. Some judicial officers really want to limit it at 2 and no more, and I would suggest that you do so as well. You could name an adult child now and have them serve, another family member serve with you now, knowing that they're going to be the one when you're gone that primarily assumes the role. But it's something to think about twice because they have the same level of duties and responsibilities you do. So if they're really not actively involved, you might want to just rely on them stepping in when you're gone. But it can be a good idea if you want to have backup. You know, it's not always easy to get a hold of one person, but you have to make sure that they can work together. You know, and they agree on matters of importance and that there aren't going to be issues between the two. And then you have to decide, do you want them to only be able to act together, or do you want them to be able to act alone, unilaterally? And if you require them to act together, that really defeats the purpose, and it can really tie their hands if you can't get a hold of somebody, one of the two, and a decision has to be made. But again, if you allow them to act independently, you want to know they're going to keep each other informed, that one's not going to make a decision that the other doesn't agree with. So those are just some food for thought. Yes.
Should a guardian be different than the person on a special needs trust, the special needs trustee?
That's a very good question. Should the guardian be someone different than the trustee of a special needs trust? There are no shoulds. Let's start with that. But when you think about the person you want as guardian and the person you want as trustee, the skill set is not the same. So it may not be in the child's best interest for that person to be one and the same. It can make life easier because the person who's the guardian then is also handling the money. So when they need to pay a medical bill, that left hand just passes it on to the right hand. But it's really about the skill set more than anything. And one thing that's nice is if they're different, I like the fact that there are checks and balances. But again, they have to be able to work together. So it's just based on individual circumstances.
Yeah, I don't know if this is, can you answer quickly or if it's just high level. You talked about we have to pay back Medicare from ABLE or from the first party account if it's dissolved. How do you, or Medicaid, how do you know how do you do that? How do you find out what Medicaid is? You have to pay back Medicaid. Do they send you a bill?
Well, yeah, they do.
Okay.
And you
So
better
they'll
check
take
it
care of
twice. Yeah, don't worry. They'll let you know how that gets paid back.
And it's from the inception of the trust and from the ABLE Act account, correct?
Well, no.
No?
So we're talking now just about the first party or self-settled special needs trust, which is very unusual for any of your children to have. I mean, we often see them if somebody was rendered disabled as a result of a negligence or personal injury, and they receive a settlement. So that's their money, and then it goes in that type of trust. But that we call it payback, goes back to the very first day you were eligible. The ABLE payback only goes back to the date on which the account was opened. And then, yes, sir, and then I'll turn it over to Emily.
You had mentioned special needs trust can be activated by the will or while you're living. Our concern is that someone may leave money to our son directly to them, and how we would handle that.
Yes.
If we need to have the special needs trust in effect before that happens.
So that's a very good point, that you're concerned that someone else might leave money to your son that would affect their eligibility for benefits, and he can't manage those assets. So we discuss that with clients on a case-by-case basis. What's the likelihood that this child could inherit from another family member? Or have you heard that Auntie Anne intends to leave something to him or her? Or, and we probe it further, like if you have a living parent or their grandparent, what kind of provision do they have? Because a lot of times there's a default that if you're gone, it goes to your kids. It doesn't specify by name. So it is case specific, but in that instance, if it is a concern, we might suggest doing the standalone trust that's existing and viable now, that you don't put anything in it, and then you communicate to whomever you think might leave something to him, deliberately or inadvertently, that you have this trust and what they need to do or how to name that trust as a beneficiary. You can't force them to do it, but hopefully that communication will assist in avoiding any issues. Because if they don't, then we're looking at a first-party trust. That's a good example, and it does happen, where you didn't realize that someone was going to leave that child money, and then they do, and now it's their money, and we'll have to do a first-party or self-settled special needs trust. With that, I want to turn this over to Emily.
Would I introduce her as your client?
Well, yes. I'm proud to introduce my co-presenter, friend and colleague, Emily Kile of Kile and Kupiszewski, and we're a very collegial group.
We are totally.
Yes, we
I can vouch for that.
we exchange information regularly, and we have fun together too. So.
Yes.
Thank you.
Thank you.
So I think I'm a little shorter than everybody else, and I can sort of see your eyeballs.
Just turn the green thing, can you go on that side?
So if I go this way so I can see you guys, but they can still see me?
Yeah, we're good. You're good.
And it's also, I think for most presenters, I know I've presented with Bridget before, we usually walk around and wander about, so I'll stay in my space. I will definitely. So my part is kind of to talk about guardianships and conservatorships and other options for legal decision making. I think Bridget touched on some of these topics, and as she said, we have the forms in hard copy as well for power of attorney forms and living wills that can be used by you or by your kids. So hopefully you'll be able to use those also. So power of attorney, as she said, is kind of the least restrictive way to allow somebody to make decisions. So for a competent adult, and it doesn't matter if you're 18 or you're 99, if you're a competent adult, then a power of attorney is most likely the way that you're going to be able to make those choices. And again, that's true for yourselves, for your parents, for your siblings, for your children. And so those are the options that's the least restrictive. Bridget went through what those documents are and what they do and how they're helpful. As she said, in Arizona we have this funky statute, the mental health statute, making decisions when somebody needs inpatient psychiatric care. Usually those are short-term stays. That's not a place where somebody lives, but it's a place that somebody goes to get treatment on a short-term basis. So usually that person will end up in the medical hospital first to make a determination about whether it's a psychiatric condition or a medical condition. So we tell our clients it's not like dropping the puppy off at the pound, that they peed on the floor one too many times, so off to the psych unit they go. There's a process in place to do an evaluation to make sure, in fact, that that's what the needs of that person are. Without a mental health care power of attorney, if somebody needed that inpatient treatment, the only option is to do a guardianship at that point, because the facility can only hold that person without their authority for a very short period of time. So even for kids with autism or other different abilities, sometimes they also have some mental health challenges. And to then be in the crisis of the mental health challenge and not have the authority to help that person get treatment can be an added stressor. So if they're competent and can sign a mental health care power of attorney, that's fabulous, and that's what it's there for. As this is the website as to where to get the 3 documents: the healthcare power of attorney, mental health care power of attorney, and the living will. They all kind of look the same on the top, so we have all 3 of them here. Just make sure that you have each of the documents if they need to be completed. Those documents only require a witness or a notary, as long as it's not the person who's the decision maker. So they're really easy to get executed. You can ask your neighbor to come over and have that completed and filled out. So we've gotten some questions about what is supported decision making. And it isn't really a formal thing. There's no thing, right? So it's the opportunity to kind of come up with a team to help that person make decisions. And there may be, in fact, agreements that are made, that if these are healthcare decisions, that this individual agrees that they will consult with mom and dad or a nurse practitioner or the health advocate that you've hired. It may be that if it's over financial decisions, they've entered into an agreement that they agree that they would not remove more than X dollars from a bank account or spend more than that amount in a month unless they also got permission from mom, dad, brother, sister, financial advisor, whoever the person is. Understand, however, that like a power of attorney, if they can revoke it anytime they want, they can choose different people. There's no consequence to saying, I don't want you to be my healthcare agent anymore, or you're kicked off my supportive decision-making team. So you obviously need somebody who's compliant and who is willing to participate in that group activity on making decisions. And if you feel that your loved one is competent enough to sign a power of attorney, again, you need to feel that they're also compliant enough that they're going to agree and allow that person to be involved. Because when you have a healthcare power of attorney, I have one, it lists my husband as my agent, I could at some point say, no, I don't want you to talk to him. No, he needs to leave the room while we have this discussion. I could rip it up and say, you know what, you're kind of irritating today, and I don't want you to be on that my decision maker anymore. So it's a choice that you have to make to figure out what's best to keep this person safe and make sure that they're making rational decisions that are helpful in their lives. And I just can't even tell you how humbled I am by what a parent needs to go through and the maze that you need to get through to get all the services in place and keep your kids safe. You know, I am one little tiny piece of it, and that is overwhelming enough to me to keep up on the parts that I have to know to help you through that. So for you to figure out all the rest of those pieces, truly humbled every day in my office by the stories that I hear and the work that parents do in order to keep loved ones safe and cared for. So I just feel that way. So I'm going to talk a little bit about guardianship, but kind of from your introductions, and of course I don't know out there in the World Wide Web what people's experiences are, but it sounded like all of your kids are over the age of 18. So I don't know whether you've already been through the guardianship process or you've determined that guardianship is really not what your child needed because you could do a power of attorney or some other system in place to help make decisions for that individual. So I'm going to kind of walk through the guardianship piece quickly because the live audience is probably that's not their priority, but there are some things that I do want to touch on so that everybody understands it, even if you've already been appointed to be guardian. So it is a court action. There is a loss of rights, most likely, for that individual because you're saying basically that you're remaining in the parent role, so you could override whatever decision that child makes for health, education, and housing decisions. So when they said, I don't want this treatment, as the guardian, you can say, well, that's the treatment that you're going to have. And vice versa, yes, I want to go forward with this experimental treatment. You could say, no, we're not going to do that. There are some decisions that a guardian may need to go back to court to make. We have a case right now where the mom and her disabled daughter believe that surgical sterilization is the best approach because she's is very sensitive to medications and feels that there might not be consistency in any other birth control method. And she's a young lady and she may participate in adult activities. And so we need to go back to court to get that approved so that everybody feels like we're on the same page. In a guardianship, there is an attorney for that incapacitated person, and so we feel like that kind of decision requires a court order for us to move forward with it. If she needed surgery to remove her appendix, certainly we don't have to go back to court for that. So in a guardianship, it can terminate driving privileges, it can terminate the right to vote, it can mean that they need your permission if they're going to get married. So these are all decisions that they may lose along the way. So incapacity, yes, sir.
You can just ask the judge though, to say, oh, I want my daughter to be able to vote.
Correct, so later in the slides, but to answer the question, yes, you can have a limited guardianship. So you can limit it and say, yes, they can still vote, yes, they can still drive. My battery is running low, so I'll talk quickly. So you can carve out any decisions you want. Those are probably the two biggest decisions that get carved out. On the physician report that gets submitted, we want to make sure that we have some evidence that the person would be able to make those choices, but I have never, in the 20 years I've been doing this, I've never had a judge say that I'm going to suspend their driving privileges when the parent is saying I want them to try, because you don't just get a driver's license. You know, they still have to go get a driver's license through the Department of Motor Vehicles. They still have to pass the test. The issue is, are we going to send information to the DMV saying that their right is suspended and so they can't even try? And even if you've suspended their license and later on you feel that they've reached the maturity or the executive functioning to drive, which quite honestly, if you drive around here, you're not sure that most of the people who have a license have. But if you feel that they could, you can always go back to court and say, hey, we want the opportunity to try. And you can do, you know, a driving school like Driving into Independence or some of the other schools and have them try it out and get a report that, yes, they're doing really well and they should have that opportunity. Nothing's set in stone, even though we call it a permanent guardianship, it's never really permanent. You can always get rid of it in the event that the person gets better and you have medical evidence of that. You can change who the guardian is. All kinds of things can change. So I'm going to go through, for time and the audience, I have in the materials kind of all the things that you have to do, what the process is to become the guardian. One of the questions that Larry had asked was, can you have co-guardians? And as Bridget said, you definitely can. But again, as Bridget said, you know, they need to be able to agree. We can't have one parent that says, you know, yes, do that, and the other parent that says, no, don't do that. And sometimes when you are in the process, the reality of the inability of parents to work together becomes very obvious. So we had clients in my office yesterday who were just coming in to sign the pleadings so we could move forward with the guardianship and the funding of a special needs trust from a personal injury settlement. And they are divorced. They live across the street from each other, and the daughter spends her time back and forth between their homes. Seemed like the perfect arrangement for all purposes until they read the pleadings and we had put in there that they could act independently. And all of a sudden it was, well, what do you mean? She could, you know, do this, or he could do that. And I said, if you don't agree, I don't represent either of you, because I don't get to pick which one I like better. So the rubber meets the road when you go to sign the documents, for sure. And also to Larry's point, we have often had parents, as they age, decide that they're going to add a child or another family member onto the guardianship to go back to court, get that person appointed, so that there's no fear of any gap in time. If it's in your will, as Bridget said, you submit the will to the probate division and that person is immediately appointed to be the guardian, and then they go through the process of seeing if there are objections. But we have had parents, as they age or they are diagnosed with a terminal condition, so that we can get somebody else on, and so then there's no gap in time, but the everybody's responsible. Everybody's a guardian, even if they're not active. We don't have backup guardians in Arizona through the court system. You can file for guardianship 6 months before a child's 18th birthday. These are all the people who get to be in your lives. Plus the court investigator, who can visit on an annual basis if they want to. Court-appointed counsel meets alone with the person. So my law partner, Jennifer Kupiszewski, does all, I write the text and then she fills in and makes it pretty, and she's, you can see what she likes. There's always a live hearing in Arizona. Everybody, the child doesn't have to appear if they don't want to, but other people do. We have a mandatory training that you do online. I wanted to talk just briefly, we talked about mental health powers, which you can get as part of a guardianship. We talked about limited guardianships. So there is an annual report that needs to be filed each year when you are guardian. For people who are out of state and who are going to reside here with their person, The guardianship can be transferred between states as long as the other state is a member of our Uniform Guardianship Act. You still have to do some paperwork, but unless if there is are no mental health powers and no conservatorship, that is, we're not dealing with money, we don't have to have a live hearing. So we get an order from the other state that says we can do the transfer, and then we file it here, then we get the letters and orders and everything done here in Arizona, and it's all issued, and we typically don't have to have a hearing for those kinds of cases. When we have a state like California that is not a member of our Uniform Guardianship Act, then we got to start all over again because they supposedly don't follow all the same rules. So at that point, we have to have an actual hearing. So it's important to know whether the state you're coming from, so you can live in our beautiful state of Arizona, whether or not they're part of the act. If you're managing less than $10,000 or only Social Security funds, you do not need to be the conservator, and we strongly recommend that you do not become the conservator, because that's to manage money. And it's a lengthy, it's a more difficult process, and there are bonding requirements and accounting requirements and all kinds of other things. If you're the rep payee for your loved one, you already have to do all of your accounting with Social Security. The court figures the federal government is looking over your shoulder anyway, so you don't have to do an action here. If there are family court orders, so there was a divorce and custody orders, we have to attach those to the guardianship petition to show the court what is going on. So the rights and responsibilities change, but the who gets to make decisions may remain the same. We talked about co-guardianship for parents. I talked about the conservatorship. You don't need that unless you're managing assets of more than $10,000 or it's not just Social Security. And you don't need a conservatorship if you're the trustee of a special needs trust. Then you're already the trustee. The court doesn't need to oversee that unless, again, personal injury funds or other money came in and the court is requiring ongoing accountings and supervision of those funds. Thank you. It's 20 after 11.
You're right on time.
So I'm good. I don't know. Yes, Larry.
Just on the co-guardianship thing, as I understand, if say a decision regarding housing, that really can't be made unilaterally. I understand that both have to agree that the ward is going to go to. We both agree on where the ward is going to live.
So in the end, all the guardians should agree on all of the decisions. The question is, can one guardian say, I'm going to consent to this housing arrangement, or I'm going to consent to this medical treatment? And if the order says that they can act independently, my position would be they can act independently, but they're all responsible for everything that's happening. So if that's not a safe environment for that person to have lived in, I'm going to guess a co-guardian is either going to have a discussion with their co-guardian, or somebody's ending up back in court to say this is not a good decision, this is not a great placement. The guardianship rules are exactly the same, again, whether you are 18 and you have autism, or you are 100 and you had a stroke, or you have Alzheimer's. We don't have separate rules for adults based on a developmental disability or a neurological issue or a brain trauma or anything. Like when you're in, and the rules are the same. So the same would be you're the guardian over an elderly parent and they need to move into some kind of an assisted living center. Now the other question is, can a guardian actually sign the contract? Well, they don't have any control over money as the guardian. So that would be a different issue as to who's signing the agreement for guaranteeing payment for that placement. And of course, if you're guardian, conservator, agent, trustee, personal representative, you always want to sign in that capacity. So it's clear you're not individually taking on that liability or that responsibility. So you're doing whatever action, you're going to sign Emily Kile, agent for Bridget Swartz. Or trustee, or whatever that role is. You want to make sure that that's really clear. Denise?
We have a question online. This family is moving here to Arizona from New York. They're in the process of getting guardianship of their 18-year-old with autism right now? Should they continue? Will this hold up their moving to Arizona, or will this be held up in Arizona?
So I don't know off the top of my head, I don't know if you do, Bridget, whether New York's part of the Guardianship Act. So they should definitely contact their attorney that they're working with to confirm whether or not New York is part of the Uniform Guardianship Act. Again, if it is, then we would just get an order when they get here, or before they're coming. They can certainly contact an attorney in Arizona and get an order from the New York court approving the transfer to Arizona. And as I said, then there are some papers we have to file, but there shouldn't be a requirement for a hearing unless they're managing money or they have mental health powers, which is unlikely because that's kind of an Arizona thing and probably not a New York thing. The statute in Arizona says you are supposed to get permission before you move your incapacitated person out of the state. And I apologize for the incapacitated person, but that's the language in the statute. So if we had a client who wanted to move to New York, we would ask them to please give us enough notice so we can do a petition to transfer and let the court know, hey, this person's going to be leaving and this is the care plan when they're not here. They're going to stay living with mom and dad, or there's this facility that they're going to be moving into, or whatever the plan is. Then we get the order to do the transfer, and then the other state accepts the transfer and you become guardian in that state. So I hope that that's a helpful answer for the question.
We'll let you know. Thank you.
Okay.
So Jay and I are co-guardians for our son. So when we pass and then we have our backup guardian take over, then who controls the finances? The guardian, or do we have to assign somebody else to that?
So Alex has a special needs trust.
Right.
So the funds for him should be managed within the trust by the named trustee of that trust.
Okay.
So the
they'll-
people listed to be the guardians will submit their paperwork to the court. They'll get appointed to be guardians so that they can continue to manage his healthcare needs and figure out where he's going to live and make sure he's okay. And then the trustee of the special needs trust will manage his money and make disbursements to pay his bills and pay the doctors and wherever he's going to live and all that stuff. Mm-hmm. Yeah. You only need a conservator if there isn't a trust. It's not just Social Security money. And there's more than $10,000. So if they inherit $100,000 and it's nowhere because it wasn't directed to a special needs trust, Grandma just said, I leave $100,000 to Emily Kile and I have some sort of a disability where I can't manage my money and I'm on SSI, DDD, and Altex benefits, then we got a different process because we got to get that into a special needs trust.
It looks like New York is, if I'm reading your map right, I'm not a lawyer, I just looked at it.
Is one of the uniform acts. So I think almost all of them are except for like 4. Yeah, the whole country looks pretty blue except for Florida, Texas, and Kansas.
And Wisconsin and Michigan.
And then it looks like there's one little, is that Connecticut or somebody over here on the East Coast? Rhode Island, what's that little white space?
It's the largest county in
No. Yeah, well, there's a little thing that's white that I don't know if that's supposed to be a place. Otherwise, there are only like 4 states, it looks like, that don't participate in the Uniform Guardianship Act. Yes?
Maybe they just working, and
Just speak up.
yeah, I'm a little bit confused on what we do with the money that he's making working. So we should not put that into a special needs trust right now.
So a couple of issues there, and Bridget can chime in as well. So if he's working and he's on SSI benefits, then of course his earnings need to be reported to SSI so they can figure out what deductions to take, and the same for his DDD benefits if he's receiving those. DES needs to know about that so that they can, again, adjust if he doesn't qualify. If he has earnings that are not being used each month, so he's going over his $2,000 limit.
He's not going over the $2,000 limit, but he's not spending all of the money he earns because he doesn't really like to spend money.
Right, so he can, so he can have, he can have up to $2,000 in his own account outside of a special needs trust or an ABLE account and retain his benefits, other than whether his SSI is going to be decreased because of his earnings.
It is being decreased because of his earnings.
Mm-hmm.
We're just really confused on on where to put his money.
So, if he's gonna go over, usually that money would either go to an ABLE account, because he can contribute up to $15,000 a year into the ABLE account, and they just passed another rule on top of that, that if where he works doesn't have a 401k retirement plan, he can actually contribute more without it impacting benefits.
About $11,000.
Okay, 11,000, and then, or he can put the money in a first-party special needs trust, but not the trust that you set up. You can't mix money that's gonna come from you or came from somebody else and money that's his. Did you have a comment, Bridget?
Well, I was just going to confirm that you should then utilize the ABLE account. I have a lot of families who come to me for that very reason, that the child is working, not spending, accumulating, or they live in an out-of-home living arrangement and the room and board is not enough to consume the income, and so they're utilizing the ABLE account to keep that individual below the $2,000 resource limit.
And they're actually very easy to set up.
Yes.
Encourage him to work, and he's making about $1,000 a month,
Nice.
and it's like,
It's okay.
I don't know what to do with
That
this.
used to be a problem, now it's not.
Exactly.
Yes. Go online, these accounts are very user-friendly and it's easy to enroll online.
And on that ABLE account, did you say that if that's put in place, that then they would have to pay back Medicaid?
Yeah.
At their death,
At their death. And
At their death?
at the beneficiary's death.
Okay.
a couple things about the ABLE Act account. Currently, you can't have more than $100,000 in there anyway, or it'll affect government benefits. So I think most of us are of the belief that if there's 50 grand in there when he dies and part of it gets paid back, oh well, it's not his whole estate. He's been getting the benefit of the government benefits for a chunk of his life, so it's not the end of the world. One of the other things about
Do
it.
you want to come up here just so other people can?
Sure.
I was gonna try and summarize it, but
Yells at me.
it was longer than my summary.
Okay, and then you can summarize, so don't go too far. You wanna
And
start
then
over?
start over?
Just a little bit.
I don't know what I said. What was
So
it?
you can only have up to $100,000.
For ABLE Act, I don't remember what I said. For ABLE Act accounts, you can only have up to $100,000 in it and maintain your government benefits. So, it's not gonna be his life savings, to live on for 20 years is not gonna go in there. We see it more of an active account that they're using for regular expenditures. So the other thing that I wanted to mention, I know I can't remember whose presentation, did you do ablenrc.org?
Art, yes.
Okay, I'll tie you in there too. Those websites will help you choose. A couple things to look for are fees. And all of them have the ability to do investments, not huge diversification, but at least some investments. And I'm of the belief that you should make sure it has a debit card. Because some of them require submitting receipts for reimbursement, and to me that's crazy. So, but again, having an ABLE Act account is very similar to your Social Security. You have to maintain record of your expenditures, because if you get audited, they want to make sure you're using it for things that they say that you can use it for. Okay?
Can I just
Just do
add for a
Come on
moment?
there, come on there.
Okay.
And Karen, while she's coming up, do you want to just let people know who you are?
Oh, sure. Hi, I'm Karen Starbowski, Mass Mutual Arizona. I do life care planning.
Well, Bridget's back, so Karen mentioned that if you're at 100,000, that it affects governmental benefits. It only affects SSI. SSI would be suspended as long as it's at 100 or more, and then if it drops below, reinstated. It does not affect Medicaid eligibility.
That's everything.
All right? And that's really oftentimes the benefit of most concern. So just to clarify, and then there are all caps in each state above and beyond that. You can't exceed, it's 400 something here in Arizona,
And I
isn't
thought
it?
it was 300 something, but
Oh,
that's
okay.
okay.
So anyway,
Wait, just stay there. Other questions?
Yeah, I just want to, I misheard, your son is getting SSI
Yes,
and he's working,
yes.
Mhm.
and you
And
said
he's coming up to the point
Yeah.
where he probably won't be getting SSI anymore.
it's 5,000 a month?
No,
5,000
1,000.
a month.
He's earning $1,000 a month.
1,000 a month. Oh, I was gonna say, because, yeah, they would, that.
Yeah. He's
Yeah, you're
making
pretty
a
close
lot
to-
more than me then.
There's another resource out there too, a website, db101.org, which will help you with computing how much you can earn and how much it will affect your benefits. I think they could hear me.
Great, so, go ahead, Ann.
Well,
We got time,
can
go
you
ahead.
explain the difference between the SSDI and the SSI?
Yes.
How that
So
would-
that's a good question, because you're often concerned about maintaining
That's what-
that individual's SSI eligibility, but what you need to understand is that benefit may very well change, and it will most certainly change when you're gone, retired or gone. So if they're working to the level that your son is, they're earning credits with Social Security. So if they have enough credits within a certain period of time, they themselves can draw Social Security disability insurance rather than the SSI, but it still assumes that they're disabled. They have to remain disabled according to Social Security. You're disabled to the extent you can't work enough to support yourself. So if they are working at a much higher level or earning with high level earnings, they may no longer be determined disabled. But over time, they're paying into the system, and so if you remain disabled, you can draw Social Security disability insurance. Some draw both, a combination benefit, because they have a low-level Social Security disability insurance benefit, and it's supplemental with the SSI. But the SSDI is not needs-based. It's not affected at all by what that individual owns or has available to them in assets. So it's
Or what they
insurance.
make either.
no, it is potentially, well,
So how much you get at the other end. So
Yes.
just to go back to the beginning, so SSI,
yes.
Let's
see it.
so SSI is for somebody who's disabled, low assets, low income, no work history. Okay? So for a large part of the population of these kinds of kids, they never had a job that was enough disabled or passes away. That child then is going to get a percentage of their parents' Social Security that they were earning or would have been entitled to, and then would get Medicare 24 months later after they're eligible for that benefit. For SSDI, that would be somebody who worked enough, paid enough into Social Security, and then became disabled, and therefore was no longer able to be employed to support themselves. And so Bill Gates could get Social Security disability. It doesn't matter how much your earnings were or what your assets are. You can have millions of dollars in the bank, but you then became disabled. So you could also have somebody who was on SSI, then became gainfully employed, paid into the system, hopefully for long enough to get some credits, and then later on becomes unable to work again, whether because that condition worsens or some other bad thing happens. And so at that point, they may get Social Security disability, or as Bridget said, that might not be enough, so they're going to get some SSI as well to sort of get them to a base level.
We have another question from New York. Does the fact that her son has a Medicaid waiver since he was 5 years old in New York expedite him getting Medicaid in Arizona once we move?
Sadly, there's no reciprocity for Medicaid benefits. All the states do their own programs. They all have their own eligibility criteria. You kind of start from scratch. Now, having said that, you have all the evidence already. You've already been through whatever joyous procedure you went through in New York to get him eligible, the child eligible for Medicaid there. So you probably will know what to do better than you would have when you started, but there is no reciprocity.
And that's as to eligibility, but also you want to be mindful of the fact that the services that are available here are different. So what you know to be the waiver services available to you in the one state won't necessarily be the same here. So it's very important to have discussions with someone knowledgeable about what does Medicaid look like here in Arizona before you make that decision, I think, to move or
And
move.
we call it weird names.
Yeah.
Yes, we don't call it Medicaid.
No, we don't.
So we call it access.
I was just going to follow up on the Social Security. It doesn't look like it applies to the folks in the room. If your parent is not, the parent is on Social Security, that person with the disabled child, adult, can apply to get half of that person's benefits.
Right, so that's what I was saying, if you're disabled, if you have a disabled child and the parent becomes disabled, retires, or dies, then that child gets a percentage of that parent's Social Security, 50% during life, 75% at death.
It's called disabled adult child benefit.
Right.
You have to have been disabled or be able to
Before
demonstrate
22.
you're disabled before age 22, yes.
On the income.
We went too long.
For SSI, do I have to keep a receipt for everything he spends his personal money on, or only as much as he's getting from SSI? It's like-
For reporting to Social Security?
Only what he spends from his Social Security
Yes,
money.
they're only concerned with your management of his benefit.
But do not blend that money.
Okay, this is what-
Choose separate savings accounts.
I made a mistake, I believe. He needed a debit card, to be able to like get his lunch and stuff like that.
Mhm.
So he has
That's
his SSI account, and then I opened an account at a different bank, and he's got a debit card for that.
So you don't want to blend, so when your SSI gets directly deposited, that should be an account solely for that.
Okay, so that's
His-
where we messed up.
And his earnings should go in another account, because what happens is, Social Security can audit you, and they're gonna see all this other stuff going on, and then you're gonna have a bigger mess of your audit.
Yeah, so I need to get his, we did the automatic deposit in his SSI, because he didn't have a different account at the time, so I need to remove that and put it in a separate account.
Or move the earnings to a separate account.
Right, yeah, it's probably easier to do
Yeah, I
that.
was gonna say, I think that's easier.
I do move the earnings, but,
But have it deposited in a separate account entirely.
Yeah.
So SSI is already set up, like Bridget said, it's probably harder to change than it is to set up a new account and put his earnings into a new account.
so I need to get his automatic deposit from his paychecks.
Exactly.
out of his
That'll be
SSI.
easier than dealing with Social Security to
Exactly.
do that.
I just did that
Yeah.
because he wasn't remembering.
And
to
it's
cash
not
his
don't
checks.
worry, you're no harm or foul here.
You just don't want it to
No.
last too long.
Yeah.
You mentioned 401K. Can he contribute to a 401K, and will that affect any of his other benefits?
Sure, he can contribute, but he can't have more than $2,000 and retain his Medicaid and his
Okay, so
other
that's not-
benefits.
And so that's why the Tax Reform Act added that if you're disabled and you can't contribute to a 401K or otherwise would, you can now contribute to an ABLE account.
But he can
In lieu
contribute
of.
at work, so he can't
Yeah.
contribute to the ABLE account those same funds, because it's the way that it was written. It wasn't if you don't contribute, it was if you have the ability to.
Hopefully, because he's part-time, he doesn't qualify.
Could you do that again? I'm confused.
So if,
So say my son is working at a job that has the potential to contribute to a 401K. And so he does that through his work. That's going to their bank somewhere,
Right,
whatever.
Fidelity somewhere.
Right. And so what happens then? You
That's
can't
a-
move that to an ABLE account.
Well, that's a problem if it's over 2,000.
Okay.
so if,
Separate or total? with
Total.
your- So down the,
So the 401K, whether he contributes, 401K is an accountable asset for SSI and all tax eligibility. So if you have more than 2,000 in countable assets, that would affect eligibility.
and then the second piece of that is the new legislation on the ABLE accounts say, if you are a person who could have an ABLE account, disabled prior to age 22, then
26.
26, I'm sorry, messing up
Okay.
my
I know.
disabled
I know.
adult children.
Too
and
many
my-
ages,
26.
days.
Then if you have a job that you cannot contribute to a 401K because you're not eligible because you don't work enough hours or there isn't one, then up to 11,000 of earnings can go into the ABLE account on top of the 15,000 that can be contributed
calendar
in a
year.
calendar year.
So, I guess that's complicated. So say
It is.
5 years down the road.
Like
you
everything
get a
else.
job
Yeah.
and, you know,
Yes.
suddenly you earn money, but you've got this ABLE account that has 401K.
So it
may-
doesn't, wait, just one second,
ahead, go
Karen.
ahead.
It doesn't have 401K
No.
money. It's still after-tax dollars. They're
Yes.
just, the government is just saying, in order to allow them to get the
Extra
same
savings
benefit
for-
that somebody otherwise would have had, basically. So you're not mixing pre-tax and after-tax dollars.
Right.
I didn't mean to interrupt.
No. But you want to keep in mind too that at some point there may be harder decisions. So if your
Yeah.
son starts making more money, it may be more advantageous. So who cares if he's getting less Social Security? As long as he's getting $1 of Social Security, he's going to get his Medicaid. So if it's right now it's $735, if he goes down to only getting $732 because he's making more money, at least he's still getting his Medicaid. So you have to weigh what's, and you can always go back on. I mean, if somebody has a meltdown.
Well, it's hard to get back on.
Well, but they
It
have,
can be.
but the DB 101, there's some trial and error for job learning to work. So there's some variances, and you can start to work, and if it doesn't work out, they're not going to kick you off right away. And I can't remember the time limits on that.
6-month period.
Yeah, something
The
like
other
that.
thing, SSI is a gateway to Medicaid, but if your children are on Arizona long-term care system benefits, that is a gateway to Medicaid or Access Medical. So you can forgo the SSI if you're on Arizona long-term care and still get your medical coverage through Arizona long-term
So
care.
it does get confusing.
Yeah, and we know this is a confusing
Yeah.
topic, and we apologize too for our friends who joined us online today for some of our technical difficulties. We've been running low on power on computers, and now the phone that's bringing this live on Facebook. So our presenters today will be around for a bit longer. If you have questions, we're also going to be posting their contact information online. So if you want to reach out to them, and thank you so much for being here this morning, and thank you so much for joining us, Emily and Bridget, and thanks for pitching in, Karen. And please continue to follow us. All the information that we presented today is online, and we do have handouts for you. And we'll hopefully see many of you back next month for our next session, which will be on health and wellness and getting your electronic medical records loaded, which is something we all look forward to, never having to fill out another one of those forms that say, tell me about the diagnosis, because that's a lot of years ago. Okay, have a great weekend. Thank you.